suspension with full pay, would the applicants have been able to advance the arguments that are being advanced on their behalf today?
If he said he was placing him on suspension with full pay, well, at least one of the arguments that we're advancing would not be competent, which is the one about imposition, because a suspension, as we all know, is something that is imposed. But the other arguments would still.
Are we playing with words in terms of leave of absence and suspension?
No.
When the one might mean the other? And are we placing form over substance?
No, Justice. You see, the president. Let me, and again, since I was listing disappointments, this is another disappointment, because the president seeks to mislead the court by creating, to justify that by pointing to the Zweli Mkhize example. And he says under oath that he placed...
Mr. Mpofu, I'm very mindful of time. My question is a simple one. Are we placing more emphasis on form over substance? Regardless of what the president may have said, the president may have used the words leave of absence. Are we here in this courtroom now, and we have to distill this matter, are we placing emphasis on form over substance? If we have to say leave of absence is this, it should have been suspension, or if the word suspension had been used, then some arguments would not have been advanced today.
No, we're not, Justice Theron. Firstly, because I've answered you to say that some of those arguments apply to both. So why would it be form over substance? And I'm saying the one argument which would not be competent, which I concede would not be competent, is the one about the imposition. I'm isolating it to that, but I'm not, that doesn't mean all the other...
Would the president, or does the president have the power to suspend a minister?
No.
And what do you advance as authority for that submission?
Because it goes back to where we started. That power can only, since we all agree, all of us in the room agree that there's no express power. That can only be found on implied powers. Okay? So there are two reasons. When the Constitution wants to, when the Constitution wants to afford the president the power of suspension, it says so. It says so in section 177(3), I think. Yes. So section 177(3) says the president, on the advice of the JSC, may suspend a judge who is the subject of a procedure in terms of subsection 1. So that's the power to suspend. It also says so in section 194(3)(a). Section 194(3)(a) says the president may suspend a person from office at any time after the start of the proceedings of a committee of the National Assembly for the removal of that person. That's to do with Chapter 9 institutions. So we don't have to be scratching to find a power to suspend where it does not exist. So if the constitutional drafters wanted to grant the president the power to suspend ministers, it would have said so, as it has done in 177 and in 194. Why is that so? It is because, Justice Theron, let's take the 194(3)(a) situation. In both situations, that suspension is pending an inquiry. right? So this is Amabungane and Nwabe now, but from the flip side. Why is that suspension pending an inquiry? Because when you are impeaching a Chapter 9 institution holder or a judge, there has to be an inquiry. But when you are removing a minister, there is no need, it is not necessary to have an inquiry. So you can't say, I am suspending you pending an unnecessary inquiry. In the other two examples, you do so, and that is why this court, per Jafta, in EFF2, made the clear distinction between a motion of no confidence, for example, and impeachment. And it said when it's an impeachment, because of its punitive characteristics, you have to have an inquiry. But if you are going to be removed as a result of a motion of no confidence, you don't need any inquiry, because that one is a no-fault removal, if you like.
Yes, I was listening quite carefully to your interaction with my sister, Justice Chitri, when she referred you to EFF1, and you accepted, as what is stated there, that where reliance is placed on Section 83 to establish exclusive jurisdiction of this court, it has to be coupled with another express obligation on the part of the President. And if I understood you correctly, and please correct me if I'm wrong, you said the obligation that it's coupled with is the obligation on the President to exercise his conscience properly and not to favor his friends. Did I understand you correctly when you said
it was one of the
obligations? Where in the Constitution now do we find that obligation?
Okay. We find that you'll find it in Schedule 2. Section 87 of the Constitution says that before you can be a president, you must take an oath of office. Okay?
I ask you to make your best point now, Mr. Mpofu.
And then in that Schedule 2 oath, one of the things it says, and anyway, Justice Mogoeng made a point about this in FF1, that the President is the only person in this country.
Are you referring to the minority judgment there?
No.
Which one?
Justice Mogoeng, there was only one judgment.
No, FF1.
Yeah, it was a unanimous judgment. There was no minority. So he made the point that the President is the only person who is required to take the oath in front of all of us. And when he was explaining.
Saying the obligation that the applicants are relying upon is found in the oath of office.
Yes, and it's the one.
Not in any section of the Constitution.
Oh, sorry, I don't understand that. The oath is part of the Constitution. It comes from Section 87. Let's go to Section 87.
Specific obligation.
Yeah, Section 87. Okay, Section 87 of the Constitution of South Africa. Which is also in Chapter 5.
Looking for a specific obligation.
Yes.
Mr. Mpofu.
Okay, I won't even preface. I will always discharge my duties with all my strengths and talents to the best of my knowledge and ability and true to the dictates of my conscience. That's what, when I refer to the conscience, I was referring to this, okay? Dictates of my conscience. What does that mean? It means I'm not going to say because it is this one or that one, I'm going to be biased in their favor.
Define the obligation for me, please, Mr. Mpofu.
Act according to the dictates of your conscience is an obligation found in this book. Yes. It is.
Finish my question.
For that
my question, please.
For that leg, yeah.
Is that the express obligation that the applicants then are relying on? The express obligation that has to be coupled with Section 83. I'm just trying to understand.
It's one of them.
Which is the other?
I said The other one, I made the example to Justice Chikri. I traced it to Section 98. And I said that once you have decided to appoint an acting minister, once you have exercised that choice, then you have an obligation to ensure that it's a member of the cabinet that is appointed. That's a duty that only one person can.
Is it an obligation or a jurisdictional fact that must exist?
Well, an obligation can be a jurisdictional fact. It's not one or the other. The fact that something
Talking about
is
exclusive jurisdiction.
yes,
Obligations in relation to exclusive jurisdiction.
yes.
Because let me
Sorry.
finish my question, please. If it's a jurisdictional fact, then that doesn't go to exclusive jurisdiction.
Why? Why? If you say, for you as the president to let's say to appoint a director of public prosecutions, that person must have an LLB. That's a jurisdictional fact.
Let me try and make it simpler. In order for this court to have jurisdiction, and where reliance is placed on Section 83, it must be coupled with another express obligation of the president, not a jurisdictional fact that must exist before the powers in 83 can be used.
No, that's not the law says it must be coupled with another duty, which is president specific and agent specific. And I've just given you two. One.
I've heard you, Mr. Mpofu.
Yes.
Let's move on.
Yes. Okay.
Now, let's go to direct access.
Yes.
And urgency. If I understand the applicants, they rely primarily on costs and on expenditure in relation to why direct access to this court is justified. Now, this is my question. If I didn't understand, you'll correct me. Does the possible expenditure to be incurred as a result of the decisions of the president which are being impugned meet the standard of exceptional circumstances that this court has held necessary for direct access to be granted?
No, not on its own, obviously. That's not what we are pleading. We are saying that the matter is self-evidently urgent, and nobody seems to have a problem with that. We are saying on top of that, this is a matter of the utmost public importance. I don't think I need to motivate that. And we're saying that the cluster of these decisions is such that they are about to be implemented in 2 days' time. At least the one decision of the appointment of the so-called acting minister. And the other decision, which is the judicial commission, which we say is illegal, is already, I think it has already started. There was a press conference yesterday. So so it's not just a question of cost, in that sense. It's a question of saying, is it in the interest of anybody that billions and billions must be spent in what might then be found in 2 or 3 years' time to have been an illegality? Obviously not. Is it in the interest of the country or anybody that there should be an acting minister that we might find in 3 years' time was not properly appointed? Obviously not. And that's why it's urgent, because the implementation it's in the one case has already started, in the other cases in 48 hours.
In relation to the applicant's claim for direct access, could the applicants have approached the High Court for interim relief in respect of the appointment of the acting minister, or in respect of the commission not starting its work immediately?
No, because the issue about I'm not sure whether we're talking about exclusive jurisdiction or direct access. As far as direct...
Let me make it clear.
Yeah.
I'm dealing now with the claim for direct access.
Yes, okay.
On the basis that there's no exclusive
Yes,
jurisdiction.
yes.
I'm dealing with the alternative claims that have been advanced by the applicants for them to approach this.
Yes. Well, then the question it doesn't make sense, because whenever you apply for direct access, you can. It doesn't mean you can't, because it's not exclusive jurisdiction. So every time you apply for direct access, so every time...
Mr. Mpofu,
yes, just...
I'll request that you at least answer the question.
Yes.
If you don't understand, ask it to be understood.
No, I understand.
Don't say the question doesn't make sense.
No. I don't mean it in a negative sense. I said that I'm the stupid one here. Yeah. So I'm saying it doesn't make sense to me. Yeah. Because my understanding, Justice Theron, if you took it differently, I'm saying that every time, when you ask for direct access, it does not mean you can't go to the High Court, because that's a question of exclusive jurisdiction. It means you can go to the High Court, but you are asking this court for direct access for the reasons that we've gone through. So
my question is, Mr. Mpofu, why could the applicants not have gone to the High Court?
Okay.
Why could they not have got relief in respect of interim relief, in respect of the appointment of an acting minister and the start of the Judicial Commission?
Yes. Okay. Now I understand the question. Because, one, the matter is of the utmost urgency. Two, it is a matter of public importance. Three, it raises important and novel constitutional questions which would inevitably end up in this court. Now, whether we want to wait for that inevitability in 4 or 5 years' time, or we want to do it now, and four, the matter, and this is common cause, does not involve disputes of fact. So all the parties are clear.
Can you refer me to the papers where the applicants deal with that?
Yes.
Where the applicants say that why, in respect of the claim of direct access, why they can't approach the High Court?
Yes, really. You'll find that on page, and by the way, in the respondents' answering affidavit, there's no response to this. You'll find it on page, I'm looking at the answering affidavit. 9, thank you. Is it 9? I'm just relying on my chin here. You find it from page 10, paragraph 15. And we've put 4 things there. We say, alternatively, and in the unlikely event of this court finding that its exclusive jurisdiction is not triggered, then the applicants will apply for direct access upon the following grounds and exceptional circumstances. 1, the matter concerns an urgent matter of the utmost public importance. I've already said that. We say the court may take judicial notice of the nationwide peaceful demonstrations concerning the Mkhwanazi revelations. The first respondent himself has repeatedly affirmed the urgency of the matter. 2, we say the matter concerns crisp constitutional issues, that's what I just said, with no need for adjudication of factual disputes. As demonstrated below, the prospects of success are overwhelming. 3, we say the very nature of the matter is such that no useful purpose will be served by taking the matter to the lower courts, which is allowed, as I explained earlier, before its inevitable referral to this court. The continuing depletion of taxpayers' money is also of relevance. And 4, we say in the totality of the circumstances, the pleaded herein, and then that obviously deals with the other facts, it is in the interest of justice that the applicants be granted direct access. In other words...
What do you say about this court's decisions in Zondi, the Tiki Dry, a number of others where this court has said that it's indirect access matters, the views of other courts are especially important
Yes.
And while we might be dealing with an important constitutional matter, that may actually sway the scales in that important matter first being considered by the High Court and perhaps the ACA for this court as to sit as a final arbiter. So the constitutional importance of the matter may actually work against the applicants, and I don't see that being dealt with in the papers.
Well, it's dealt with in the 15.3. Let me repeat again. We accept that the matter, as I said earlier to Justice, there's nothing stopping that's direct access by implication means that the matter can go to the High Court. But we say that...
For you, just to preface it, it's on the applicant to show why it should be decided by this.
Yes. Why? It's because if we did that and waited for the matter, what we call the inevitable referral to this court, as I say in 3, I'm just guessing, 3 or 4 years' time. If we waited for that inevitable arrival of this matter to this court, by then there would be no country left in the sense that you would have had an illegal...
Is that dealt with on the papers? Yes.
Justice, when we say the very nature of the matter, then let me pause there and tell you what the very nature of the matter is.
No, I think all judges understand the nature of the matter. It wasn't clear to us there'll be no country left as the submission that you made.
Yes. So the nature of the matter, the nature of the revelations, the nature of what we're dealing with here is such that, so when I say the nature, I don't have now in this and then say that nature is ABCD. That nature is in the founding affidavit as it is. So when I'm dealing with direct access, I'm dealing with someone who has read the full affidavit, who knows that we're dealing with implied powers that may not exist. We're dealing with 3 acting ministers and all that. We're dealing with a judiciary that is investigating, that is being investigated by a member of the judiciary. We're dealing with the possible usurpation of JSC powers and all those things. That's what we mean by the nature of the matter.
I have 2 more questions, Mr. Mpofu. The one relates to separation of powers.
Yes.
We look at Section 85.
Yes, I have.
Section 85 vests executive authority of the Republic with the President.
Correct.
Now, would it not imperil the separation of powers if this court was to interfere with the President's exercise of his authority?
Yeah. No, it wouldn't. It wouldn't, Justice Theron, because all the cases, including all the cases against the President that were ever brought to this court have made that point, that the general rule is separation of powers. But the exception to that general rule is the standard of rationality. That's right. So the fact that the President can, we're not in England where the Queen can do whatever they want. Here we have a constitution. So the President can do whatever he wants, but it must be rational. And who are the determinants of rationality? Judges. So the only place, once you feel that the President has done anything that's irrational, there's only one place where you can go to. It's a court of law. If that court of law is going to say, well, go back to the President, well, then we'll have no country again.
Mr. Mpofu, if the court is not with you on the merits, what are your submissions about costs?
The 2 applicants, at least, well, in short, BioWatch applies.
Now, the applicants, and I think, have made numerous allegations that don't directly relate to the merits in this matter. They refer to the President protecting Minister Nkunu because he's a political ally. They refer to Phala Phala. They refer to State Capture Commission, which don't directly relate to the legal questions in this matter.
In what ways, Justice?
And if they don't directly relate to the legal questions, is the applicant's primary goal political? And should they be spared from costs?
Okay, first let's start with the first leg. I can't fathom why the allegations, which are not denied, by the way, about what we call the factional or political affinities or the historical relationship between the president and Minister Mchunu. Everybody knows that they were the two top of the ticket in the so-called CR17 matter that has come to this court before. So I'm sure this court is familiar with it. Everybody also knows the Phala Phala matter has also come to this court. So everyone knows that that matter is in the public domain, even if it had not come to this court. So if one makes, you can't just, if you wanted to impose costs on the applicant, you would do so if they come and said, no, the president is just biased, without substantiating. But when they substantiate, and you want to punish them for substantiating why they're saying the president is the reason why he is treating Minister Mchunu differently from Deputy Minister Whitfield, is because the one is his political ally, and explain why. If you're going to be punished for that, for substantiating, that it might not be so is a different matter. But to be prohibited by a court from saying it, then again we'll have no country. Because it would mean nobody must say what is, must even allege, let alone anything about this president. They mustn't allege it, let alone having to establish it. Well, that's fine then. Then in that case, yes, the applicants should be punished for expressing a view about why they are saying the president is biased in this particular case. Then they can be punished or face the. Yes. Oh, sorry. And in any event, it's interesting, but the president is not asking for costs, let alone punitive costs that are now being suggested. And I'm sure it's because the president understands. In fact, the president has dealt with those issues, with the Phala Phala and the. Sorry.
Mpofu, nothing has been suggested. Questions are being posed,
yes,
on
okay,
which we
yes.
would like to hear your views.
Yes. No, I'm saying
Just
yeah.
to make that clear.
Yes.
But you've answered my question.
Yes.
Thank you very much, Mr. Mpofu.
It's a pleasure.
Justice Mhlantla.
Mr. Mpofu.
Yes, Justice Smith.